In this video, we're going to talk about the recent U.S. Supreme Court Wolford versus Lopez decision and why it could matter if you carry concealed in New Jersey. Let's get started. A lot of people have been talking about this, folks. It happened last week. The U.S. Supreme Court just decided a Second Amendment case out of Hawaii. It wasn't about AR-15s, and it didn't strike down New Jersey's assault weapon ban. But within 24 hours, attorneys in both of New Jersey's biggest Second Amendment cases filed new briefs with the Third Circuit telling the judges this Supreme Court decision matters and to consider it while deciding the New Jersey cases that are still pending. Today, I'm going to explain why. This case, Wolford versus Lopez, challenged Hawaii's law that made virtually every private business off limits unless the owner expressly allowed firearms. So grocery stores, restaurants, gas stations, retail stores, coffee shops, any privately owned business that was open to the public was off limits unless the owner gave express permission. Now, keep in mind, folks, this is the same anti-carry law that New Jersey has in place, but it's currently not being enforced pending litigation of the cases that I'm talking about. The Supreme Court held that Hawaii's default prohibition violated the Second Amendment because it actually flipped the traditional common law rule. The court concluded that law-abiding permit holders could not be required to obtain advance permission before carrying in businesses open to the public. So for my New Jersey concealed carriers, we have the same restriction in a fairly new anti-carry law. This was signed December of 2022 by then Governor Murphy. Remember, Bruin was decided June of 2022. So places like New Jersey and New York got right to work, the anti-gun politicians, crafting these laws to prevent carrying in pretty much the entire state. Part of this anti-carry law is not being enforced in New Jersey currently, pending the Third Circuit's decision. So if you're from New Jersey or you have a carry permit in New Jersey, stick around because I'll explain why this affects you and your right to carry concealed. This opinion wasn't just about Hawaii. Much of the decision explains how the courts should analyze Second Amendment cases. The Supreme Court emphasized again that the two-step framework the lower courts should use when analyzing these cases is, does the restriction or the law that the government puts in place, is that conduct covered by the plain text of the Second Amendment? If yes, the government, not the citizen, this is important, the government must justify their restriction using this nation's historical tradition of firearm regulation. It's important to note here, folks, that the impact was immediate. Within one day, attorneys for New Jersey's pending Second Amendment cases, we're talking about Koons and Siegel, two separate cases that were consolidated to one, and the Cheeseman case. So the attorneys representing these two plaintiffs, or multiple plaintiffs, were already asking the Third Circuit to apply the Wolford decision before issuing its decisions on these New Jersey cases. So after Wolford was decided on June 25th, attorneys representing the challengers in Cheeseman filed a Rule 28J letter the very next day, arguing that the Supreme Court clarified how courts should analyze Second Amendment cases. The attorneys in Koons and Siegel also filed a Rule 28J letter citing the Supreme Court's reasoning and explaining why they believe it should influence the Third Circuit's decision on New Jersey's carry restrictions. So here's where things get interesting, right? Because the Cheeseman attorneys are arguing that Wolford clarified how courts must analyze Second Amendment cases. Specifically, New Jersey, the attorneys for New Jersey, have argued that the plaintiffs first have to prove the banned firearms are in common use. The Cheeseman attorneys say Wolford rejects that approach. Instead, the first question is simply, is it an arm protected by the Second Amendment's plain text? If yes, the burden shifts to New Jersey. But that's not all, folks. The Koons-Siegel attorneys also cited a recent U.S. Supreme Court case, Hamani. And in that case, that involved an individual who admitted to regularly using marijuana. He was arrested, he was charged, and the decision was that the state or government cannot strip the Second Amendment rights from someone simply because they regularly use marijuana. Now, you have to consider other factors, of course, And this case was specific to a certain individual under certain conditions. But that case is important, and the attorneys for Koons and Siegel brought that up as well. The Supreme Court emphasized that historical laws are not valid analogs simply because they promoted public safety. So, for example, New Jersey can't simply say a law promotes public safety, so that's good enough. The courts have to determine whether history supports that particular type of restriction. I should clarify what the Rule 28J letter is. That's simply a procedural rule that lets attorneys notify an appeals court about a significant new legal development after the briefing is complete. So it's not a new lawsuit or a new appeal. It's not new evidence. It's essentially a letter saying, Judge or judges, before you issue your decision on our case, the Supreme Court just released a case that may affect how you analyze this one. That's exactly what happened here. Within a day of the Wolford decision, attorneys in both of New Jersey's major Second Amendment cases filed Rule 28J letters asking the Third Circuit to consider the Supreme Court's latest guidance before ruling. So don't forget, folks, that New Jersey has defended its firearm laws primarily as public safety measures, right? That's their argument. It's in the interest of public safety. The Supreme Court has now reminded lower courts they can't simply accept those assertions at face value. Instead, they have to compare purpose, operation, historical analogs. That analysis is exactly what the Third Circuit is now performing. So we're all waiting for the decision on these two New Jersey cases from the Third Circuit. So hopefully the briefs filed on this recent U.S. Supreme Court case will cause the Third Circuit to perform their analysis correctly. Now, if you watch the channel and you're from New Jersey, you know that we've done videos on New Jersey sensitive places restrictions. Some of the restrictions are being enforced. Some of them are not, pending the Third Circuit's decision. But I should mention specifically this vampire rule, or the same case that Hawaii, the Supreme Court just decided on for Hawaii. Some people call it the vampire rule, and you've probably heard that if you've been watching other videos on this decision. If you're not familiar, it's named after the mythical lore of vampires. Of course, if you watch any vampire movie, you'll know that they can't enter a home uninvited, right? So the anti-gun politicians are trying to be clever, and they're trying to come up with restrictions that prevent law-abiding citizens from carrying anywhere. So they came up with this law in Hawaii, also in New Jersey and other states, where they say even if it's private property open to the public, unless the owner is giving you express permission to enter with a firearm, you can't enter, which is absurd, because if you think of a gas station in the middle of the night, first of all, the owner's not going to be there in the middle of the night. A convenience store, a lot of the stores in general, unless it's a small family-owned business, chances are the owners aren't even going to be there. So you show up at 3 a.m. to fill up your gas tank, and these politicians, these anti-gun politicians, are saying you're not allowed to carry your gun that you've been totally vetted with a background check and fingerprints and fees and training requirements if you live in New Jersey. You can't carry at this gas station at 3 in the morning to protect yourself and your family unless the owner has expressly given you permission. It's kind of absurd. So this win, I think it's a huge win for Hawaii. The Wolford case, to me, makes the decision potentially relevant beyond Cheeseman, because it's basically the U.S. Supreme Court is telling the lower courts, this is how you need to evaluate these cases. When the state or states or government makes these laws or restrictions, this is how you have to apply it. It's after Bruin. This is how you have to apply the test and do the analysis. So that makes the decision, I think, relevant beyond Cheeseman. I'll put links to our other videos that we've done on this for more information in the description if you haven't seen them yet. I should also mention that earlier this year, New Jersey attorneys representing the state of New Jersey submitted supplemental authority filings asking the Third Circuit to reject the Benson decision, I'll tell you about that in a minute, and continue to uphold New Jersey's assault weapon and magazine restrictions. Now, remember, Benson was a District of Columbia, D.C. case, and the District of Columbia Court of Appeals struck down D.C.'s ban on firearms magazines that hold more than 10 rounds. The court ruled that the prohibition violates the Second Amendment, noting that high-capacity magazines are commonly used by law-abiding citizens for lawful purposes. So that's important, folks. So New Jersey tried earlier to say, hey, Third Circuit, please don't consider this D.C. Court of Appeals case because it hurts their case. So now the plaintiffs have responded with Wolford. So both sides are actively trying to persuade the Third Circuit before those decisions are released. So one thing I've learned, folks, over the years is not to predict court decisions. Courts sometimes surprise everyone. But what we can say is this. When the attorneys immediately file supplemental authority over a Supreme Court decision, like they did here in Wolford, they believe that decision could influence the outcome. In closing, folks, I wanted to mention that Wolford did not strike down New Jersey's assault weapon ban. It didn't eliminate New Jersey's carry restrictions. What it did do is remind every lower court, including the Third Circuit, which we're all waiting for to decide on these cases, how Second Amendment cases should be analyzed. Now we wait and see how the judges apply the guidance. I'll try to keep everybody up to date. Thanks for watching. Take care, and we'll see you in the next one.